I checked the Sarah Boone docket tonight, and my eyes immediately went to the length of the latest document before I saw the name, and I had a little bit of trauma come back as someone who has read the Sarah Boone letters handwritten in what I can only describe as Sarah Boone font. That is not what this is. What this is a transcript for October 2nd. And why some of you might find this so fascinating is if you didn't follow Sarah Boone until trial day 1 when the jury was brought in, you did not see this. And a lot of people only started watching then. This was the defense trying to get all of the police interrogations thrown out, claiming that Sarah Boone's Miranda rights were violated because it wasn't read to her properly enough. This is a full transcript of that day, so it will include the argument of that, testimony with the detective that interviewed her, testimony of Sarah Boone, closing arguments from both sides, and a motion for cosmetics and hair and, clothing and no restraints. All of that, right? So what I'm going to do in this video is I think, just for myself as a refresher, I'm going to be reading through the testimony of Sarah Boone that day. And since I was going to read it for myself, I might as well have it available for you in a YouTube video, and I can add my thoughts as I go. I do want to apologize if I have to stop because I cough. I'm going to be honest, the cough that I had covering Sarah Boone never fully left. I'm going to be completely honest. I don't know what it is, and it sometimes acts up, and today is one of those days. Maybe I'll die. Let's just get into it. We have Mr. Owens. Ma'am, would you please state your full name? Sarah Boone. You're going to have to speak up or move closer to the mic. Sarah Boone. Judge, if I may, yes. Where are you currently housed at the Orange County Corrections Department? Have you been there since February 25th, 2020? Correct. Was that the date of this interrogation that we're here for this motion? Yes. Let me take you back to the morning of finding George Torres in the suitcase. You called 911. Yes. Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived? Yes. And then the question that has been very important. What mental state did you have at that time? I was very confused. It's very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation. And then trying to focus on everything that was going on at my home, I was hungover. I was still, I believe, intoxicated to a degree. And we have Mr. J. Objection, Judge. Move to strike. This is outside the motion to suppress. They have not made any allegations her statement was involuntary because of her mental state or state of intoxication. Court response. Judge, we're talking about, I'm just getting some preliminary information. Her interrogation is the next day. Court, the state has an objection, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and surprise. Mr. Owens, okay, this is the day before the interrogation. The court, I understand that. We're not talking about intoxication. The court, but you are going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25th. Are you going to bootstrap or link any of those things together? Mr. Owens, the interrogation in the squad car and what was said to her prior to getting into the squad car, that relates to what she said about it being routine protocol. Yes. And then the court says, I'm going to sustain the state's objection. Relating to intoxication? The court, yes, it wasn't raised in any of the 3 motions that have been filed. Mr. Owens, I can remember this line. I can feel this line. Judge, I didn't ask her that. She volunteered it. The court, I understand. Objection sustained and stricken. Mr. Owens, all right. Now, Mr. Owens again. Did you speak to the deputy about what had happened? Yes. Okay. And then were you asked to stay on scene? Both, yes. By both detectives, yes. Okay, how long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez? It was not right away. I don't know specifically, but it was not quickly. Okay. Did the two detectives, when they arrived, did they take over the investigation? It was my understanding, yes. Mr. J. Objection, no foundation for her to conclude anything. The court, sustained. Mr. Owens says, at some point, were the detectives directing you what to do, where to go? Yes. Question, okay. Can you explain what the detectives told you as it relates to getting in the car? Was the phone an issue before the car? Mr. J. Objection, compound question. The witness. Yes. The court. Sustained. I remember that too. Her squeezing in the answer. By Mr. Owens. Let me ask about the phone. When were you first asked about your phone? By the way, I'm sipping so I don't cough. From my remembering, it was once they arrived, one of the first questions that Copsel asked me was if I owned a phone. And what did you tell her? I told her it was on the kitchen counter. Question, all right, and what happened next as it relates to the phone? I believe that it was brought to her with someone else. I don't remember. Mr. J. Objection calls for, she's speculating. The court sustained. And even like this early, like obviously we know at this point this didn't play out. This didn't work, right? But just it's I don't even know how to put it. There's a Sarah Boone-ness to it. Like the way she talks and answers things, like you can feel she's trying to manipulate it, which I mean is what you're gonna do as a defendant, right? But let's just get a little deeper. I'm sure I don't remember all of it by heart. I'm sure it gets more interesting on the cross. By Mr. Owens, what was the next thing that you were told or talked about as it relates to the phone? Answer, unlock it. Who told you that? Detective Copsel. How did you unlock it? She handed it to me and I unlocked it. How do you unlock your phone? It was with a passcode. Okay, and when you unlocked it, did you give it back to the detective? I did. Question, did you ever see the phone again? I did not. Okay, after that incident, was the next time you were spoken to by Detective Copsel was in relation to the interview in the squad car? Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle. And did she tell you anything about what was going to take place once you all got inside the vehicle? That she was going to be asking me general questions. All right. Was there ever any mention about normal protocol? Not that I recall. Okay. What about once you got in the squad car? I don't recall in the squad car. Okay. And that was recorded for the court to consider. And so she read you your Miranda rights. Yes. All right. Did you answer the questions? I did. Did they ever indicate that you were a suspect? No. Did they ever indicate to you that you were a person of interest? No. Did they ever refer to the videos that you record on your phone from the night before? No. Were you ever questioned about those videos at the scene? I was not. All right. After they finished interviewing you in the unmarked vehicle, were you allowed to get out? Yes. Were you allowed to leave the scene at that point? I was instructed by both to not. Okay. How long did you stay on the scene? The entire time. How long? How long was that? How long did it take before the investigation was completed? 10 or more hours? Okay, at some point did they all leave? Yes. And at some point did they tell you they were finished with the work there at the scene? Yes. What did you do? I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located. All right, and how far away was that? About 5 minutes. How did you get there? I drove. Okay. What was the reason that you wanted to stay over there that night? Because I was terrified of his family. Now, later that evening, you were going to spend the night there with your son and with your ex-husband, correct? Did you do that? My son, yes. That's interesting. I don't know if I caught that before. I mean, her husband was there, right? I would assume. So I guess she just didn't want the insinuation she slept with him, which, I mean, the jury's not there at that point, so. All right. Later that evening, did you attempt to contact Detective Copsel? I did. Whose phone did you use? Former husband. Brian Boone. You said your phone had been seized? Correct. You had consented to that. You signed a form allowing them to take the phone? Yes. Had there been any discussion about returning the phone? Copesel told me she or Lowen, or both, would return back to my apartment to return my phone. When did they tell you this? Before they left the scene, which that was not something that actually happened according to the detectives. And did they tell you they would return your phone where? To myself at the apartment. And is that what you understood they were going to do? Yes. Was there any talk about you coming to the sheriff's department that day of this event? No. Alright, so later that evening you borrowed your ex-husband, Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number? She gave it to me before she left the scene. Did you call her? I did. Do you recall about what time you called her? I believe it was around 9:30 or 10. And that would have been on February 24th of 2020? Yes. Now, I might be misremembering, and I think it gets brought up in Cross, but I think her timeline doesn't even work. With like how long she was on the scene and time she claims to have called, I don't think the timeline works. Alright, can you tell us why you were calling her that night? Before she left and given me her personal cell phone number, she told me if I were to recall anything, or if I wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt uneasy about how they left. Mr. J, objection, her mental state is not relevant. The court sustained. Mr. Owens, go ahead, repeat the question. Objection sustained. There's no pending question. The court, there's no pending question at this time. Mr. Owens, okay. You were concerned about the case and you wanted to call her. Yeah. And did you talk to her? Yes. What did you say to her? I told her, in all honesty, that I felt that she was trying to trick me. Objection. Irrelevant what her state of mind is. Sustained. Mr. Owens says, did you have a conversation about your phone? Yes, I asked her. Mr. J, objection. Answered. The court overruled. You may answer the question, ma'am. Mr. J, judge, it's called for a yes or no. She said yes. Now I don't know what's pending and how to object to it. Mr. Owens, did you all have a discussion about your phone? Yes. Can you elaborate on that discussion? She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone. Was there any discussion about you being interrogated at the sheriff's department? No. Was your understanding the sole purpose of your going to the sheriff's department the next day was to pick up your phone? Yes. And the sole reason for the change in plans from them bringing the phone to you was because Detective Copesel was pregnant and not feeling well. Correct. So next afternoon, did you drive to the sheriff's department? I did. Tell us. When you parked your car, where you went, what happened? I parked my car and left everything as regular in my car. I walked to the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over a particular window. He says, no, your phone is upstairs, so we'd like for you to come upstairs. That's where you can pick up your phone. All right. And so did he escort you upstairs? He did. How did you all get upstairs? In an elevator. And what was he wearing? I believe he was wearing a red shirt along with his firearm and black pants. His firearm was on his waist? The entire time, yes. Okay, so you all got off the elevator. Where did you go from there? He brought me into a very small room. They had to sit me down, and then from there I had a list of things I was going to ask them that I might need to do or that I could do. Yeah, her list. I forgot her list for a moment. Okay, so from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, correct? The audio and video, you didn't go anywhere else? No. Prior to that time, was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything, before walking into that room? No. Okay, so directly off the elevator and walked into the interrogation room. Correct. Then we have the video of that. And now you have watched that video, correct? Yes. And you've seen the motion where I was referring to the question where she asked you to sit down. Yes. Do you recall what happened? Yes. Recall that happening? Yes. Did that refresh your memory watching the videos? Yes. Do you recall her saying that she had received the autopsy? Yes. Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy? Yes. This was prior to you being read your Miranda rights, correct? She also said, we're not done talking about the incident. Do you recall that? Yes. And then she said, we just have to do it. Yes. How did that make you feel? Objection. Relevance. Sustained. Were you trying to comply with the officer's demands? Objection. Relevance. Overruled. The witness, Sarah Boone. In every way. By Mr. Owens. Were you trying to cooperate? In every way. Were you polite with them? Very. Oh my gosh. Oh. And when she said that, you just have to do it, you said, just like we did yesterday? Yes. And then you said normal protocol. Yes. Is that what she had said the day before? What do you mean? Normal protocol. Yes. So, by the way, I've rewatched, this is an old video I did, I've rewatched footage of someone that came to the scene, some officer, detective, I think it was an officer, whatever, it doesn't really matter. I watched them, and they mentioned the word protocol. And I believed, I still do, at that time that's where Sarah Boone clung to that word. That's why she kept using protocol and using it with the police who were like repeating it back at her, I think a couple points. She like zeroed in. It was like the protocol, I think, of putting up the caution tape or police tape or whatever you want to call it. Police tape, but crime scene tape. Protocol. That's one of those terms that every time I hear it, it's like little response from like Sarah Boone. Had she said the same word you said normal protocol to her? I was reiterating to her what she had said to me the day before. So she read the Miranda rights to you, except number 9. Except 9. Number 9. She said the rights, and then she said, do you understand what I just read to you? And you had agreed, yes. But you were told, but you were not read, having these rights in mind, you agree to speak with me now. Mr. J, objection, relevance, overruled. The witness, I was not asked that question. Mr. Owen says, is it fair to say that after she read the Miranda rights, after she said, do you understand the rights that I've read to you? And she went right into questioning. Yes, she did, correct. So she never got an answer from you. Do you agree to speak to us now? She says, I was never asked that. The way that she acted, the things she said, the fact that you had your phone, did you get the impression you were not getting your phone back if you didn't answer the questions? Mr. J, objection, irrelevant, she was in custody. Sustained. Mr. Owens, she was in custody? Oh, another moment flashing back. It's like, yeah. Yes. It was the court, it was conceded by the state there was a custodial interrogation. Mr. Owens, but she wasn't aware of that. She wasn't aware she was in custody. And the judge says, what does her subjective perception matter? So much of this is about Sarah Boone's feelings, right? And her not realizing what's going on. Isn't that funny? Isn't that funny? Like, imagine you're brought into an interrogation room. You read your Miranda rights. And you leave and go, huh, was I in custody? Yeah. She wasn't free to leave at the scene either. Mr. Owen says, well, under the circumstance, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was, court, That goes to whether or not Mr. Owens being questioned. She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position that she was coerced into answering questions. The court. What does that have to do with coercions? Those are all factors under Ramirez as to whether or not it was custodial. Those are all factors under Ramirez as to whether or not it was custodial. Mr. Owens. Well, I know some of the factors are whether or not the interrogation actually happens at a police station or not, or whether it happens outside the police station. So just that environment alone, the court. That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that, being non-compliance with Miranda, coercion, or the third ground of voluntariness. Mr. Owens. Well, I think it goes subjectively to her and what she's feeling, and if she had a free choice or not based on the court. What's the subjectivity matter? Mr. Owens, excuse me? Based on the court, what's the subjectivity matter under the case law? Case law. The biggest bane of Sarah Boone's lawyer's life. Probably gets woken up at night hearing the word case law from like the corner of his room. Based on the circumstances she was dealing with at the time, whether or not she felt she had a choice. What does her subjectivity have to do with that? Mr. Owens, I believe it's relevant. The court says objection is overruled. I'm sorry, the objection is sustained. I apologize. Gave him some false hope there, Mr. Owens. Do you understand you are not going to get your phone back until you answered their questions? Mr. J, objection, relevant, sustained. I mean, we're just re-arguing the same thing, right? But Mr. Owens does move on. Did you have some questions for them at the end? I did. Did you feel like you had a choice in answering their questions? Objection, relevance, sustained. Mr. Owens. Ma'am, that day you came to the sheriff's department to get your phone? Yes. Did you know that you were going to get placed into custody? I did not. Did you know that you were going to be arrested? I did not. Did you know that you were going to be questioned? I did not. Were you trying to cooperate with law enforcement based on her statements that you have to talk to us? Yes. Objection. Relevance. Overruled. Were you there answering her questions because she confirmed this was normal protocol? That was my understanding, yes. That's all the questions I have. Cross-examination? Yes, sir. By Mr. J this time. Ooh la la. So that afternoon on February 24th, 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct? Yes. You were impaired by alcohol, correct? I don't know as much as impaired means. It did infect, yes. Okay. And that was consumption from the night before, correct? Yes. So you did not go to the brunch that morning and have mimosas or anything else to drink, correct? Correct. And you would consume no alcohol in your home that morning, correct? Correct. And it's just so different, by the way, like the way they speak between the two sides. So does it affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon? Ask me one more time, please. Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon? Now or then? Then. Did alcohol affect my conversation with her? There's a jury instruction that says a witness's memory and perception is pertinent. I'm asking you, did the alcohol you were under the influence of, did it affect your memory or perception of the events that you testified to today that happened on February 24th, 2020? So, did it affect my answers? Judge, I don't think she understands the question. I don't. It's been asked 3 different ways. She just doesn't want to answer it, Mr. J. So we'll leave it that you were under the influence of alcohol, correct? Mr. Owens. Judge, I think she said she didn't know what... She said she had alcohol under the influence or impaired. The court. The objection is... The court does not entertain speaking objections. Legal grounds need to be provided. What are the legal grounds for your objection, Mr. Owens? I know that she said she didn't know what... The court. What are the legal grounds for your objection? Mr. Owens, I'll withdraw it. And the court tells Mr. J to proceed. And see, it's just so different, right? Like when the prosecution objects, it's very in this case, it's very surgical. It feels like they know exactly why they're objecting. But there, Mr. Owens, it was like Sarah Boone was begging for an objection, right? And he was trying to fulfill her need, and he couldn't come up with something. Mr. J says, and you understand that you're charged with second-degree murder in this case, correct? I do. You're facing a potential penalty of life in prison, correct? I understand. Do you understand that the score sheet minimum is probably about 22 and a half years? I don't know. Okay. And it is your desire to have these statements excluded from the jury's consideration, correct? Judge, I would object to that. Sustain the objection. Mr. J, your intent is to testify differently than you have testified in the State's Exhibit 1, in the statements in State's Exhibit 1, correct? Regarding the judge says, Mr. Owens says, Judge, I would object to that. I'm not understanding what the question is. The court, Mr. J. Mr. J. Judge, a witness's bias is always at issue when they take the stand. It's our position, her credibility for all the things that she's testified to today, that particularly the things in conflict with Detective Copsel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witness, and you are in the best position to do that. The appellate courts are going to be very differential to you. It's our position that she's biased. And see, this is where it gets really interesting, because he brings up the appellate courts already in this. And that's what she's dealing with now. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison based on the examination that both state and defense counsel and the state's expert witness today. It's the state's belief that she is intending to testify differently than she testified in the statements provided to law enforcement in State's Exhibit 1. And therefore, she is biased in all the things she's testified about today, because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so she is not going to be cross-examined and impeached with it. So she can testify the way that she testified this afternoon. Court response. Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 on the low end, and I agree with all that. We just got through at the jail meeting with the state's expert to evaluate Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now if he's going to question her about what was said during that evaluation, and he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here. That's the court, Mr. J. I'm not specifically asking her about what she said that is different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to intrinsically impeach her with that due to the brevity of the time frame we have all been subjected to. But I do believe it's a fair question to ask whether or not she intends to testify differently than her statements that are in State's Exhibit 1, and consequently, with how she testified this afternoon, and that she understands it would benefit her if these statements were excluded. The court. So I'm going to sustain the objection based on how the question is asked, although I'll allow you to revisit it based on how you explained it to me. Okay, give me 1 second. So basically, the argument here boils down to, is Sarah Boone trying to get things thrown out so she can tell a different story in front of a jury and not have those statements, she lied because here's what she said before, right? Basically boiled down. And he's trying to get it out of her to admit that that could be what's going on. She's biased in that way. By Mr. J, you gave statements to an evaluator this afternoon, did you not? I did. All right, and without going into details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020? Yes. And you understand that I will be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct? I understand. So you understand the benefit of this motion to suppress being granted. Of course. Mr. J, no other questions? Any redirect? No. Okay, and they had her bring back. And then it was just the closing, which if you want to, I mean, it's there. It's available if you want to see the closings. I'm gonna be honest, my throat's a little I can feel coughs going on, so I'm not really physically up to the rest. Or I would. But I'd say this is also all there in the, you can just watch it if you want to as an option. I just wanted to cover the Sarah Boone part because I thought that was interesting. 107 pages for a single day. There's going to be more, I assume, big documents like this, more transcripts. They have until April. I think the extension is April 11th now to get all the transcripts that were requested done. So things like this are going to pop up periodically. If you like this content, let me know in the comments below, and I might cover more of the testimony, like key moments from the trial, if they're in those transcripts, and then you can read them all on your own time if you'd like. But thank you for watching the video. Ran into a Sarah Boone update I wasn't expecting, and I just kind of had the time to jump on and do it. I mentioned this in a community post. I do have what I believe, I've scrubbed through it, I believe it is the raw interrogation footage of Melanie Gibb. So I have that on the back burner for whenever I find time to cover it. Add some commentary, talk about what's going on, talk about what we know, my opinions on some of the things she says. I've been told it's a little crazy. So she talks about Lori's beliefs. And I have all of that there whenever I find a moment. So just know that's out there. You can look out for it. And I'll see you in the next video. Take care. And if you haven't been checking the community posts, you should do that. A lot of things that I might make like a 1 or 2 minute video on, instead I've just been chucking up on the community posts unless there's major updates, just little things I find interesting throughout the news, things I might work on or might do. And if you haven't checked out my video on the snow plow shooting thing, I don't know exactly what people are calling it. That case, there's some interesting developments today where the victim is not wanting to testify.